You have to confront the impossible before you fucking hit the iceberg. Am I correct?
If someone is punching you, you can either block it, dodge it, and then punch back. And if you don't punch back in this market, you're going to get hit eventually.
Welcome back, everybody, in Confronting the Impossible. We have a very special guest, partner at Jacobs PC, Adam fucking Sherman over here. Sherman, thank you very much for joining us today.
Thank you for having me.
I want to talk about business strategy, okay? A lot of our clients know what their business problems are, but they don't know what their legal issues are, right? I want to talk about how you specifically in the business litigation department, and you head the department at Jacobs PC, you go through a lot of adversity. You go through a lot of change and emotion, the audacity of hope when it comes with resolving problems for our clients. And I want you to use anecdotes and positions that you've created, some who have been lost, some that have been won, in telling the crowd and the people what it takes to be a business litigator in real estate. Tell us about that.
So look, one of the things that I've seen, and I've had this conversation over and over again, is that business people do not know when they are in litigation. What do I mean by that?
Yeah, tell us about that.
I don't mean that, when they get served with a complaint. I'm talking about you're in litigation when you have a semi-big disagreement. You are in litigation even if you don't feel it. It's there. And a lot of the things that we've kind of gone over, and what I think is really the most effective way to resolve things efficiently, cost effective, and really the best result from each business client is at the very beginning, right when there's a problem. The best thing to do is you call a lawyer, frankly us, and then you analyze each permutation from a business and a legal perspective together, where you figure out, well, this person did this. I believe it's breached the provision of a contract. What happens next?
So are they afraid to do that with us, though?
Absolutely.
Well, why do you think they're afraid? What's going on in their head? What have you learned when you talk to the clients?
Number one, no one wants to talk to a lawyer in the very beginning. Everyone thinks it's going to be resolved, and then they're sitting in a deposition 6-8 months later, and guess what? They're in the hole a lot more money they would have been if they just had made a call at the very beginning.
So how do we train our clients? And I don't want to say train, but that's what it is. You got to hold their hand. How do we train our clients? What do we do differently at Jacobs PC? And I think we do something very, very different, but I want you to state it. What do we do in communication, synthesis, legal direction? What do we do differently when we're talking about our billionaire clients, our millionaire clients, and our thousandaire clients? Tell me about that.
Really, when there's an issue that cannot be resolved on the phone, you have to really get us in and really figure out what your options are from a business perspective and a legal perspective in terms of what can get us to the table the quickest.
Okay, so I want to use an anecdote, okay, and the way that we should be brought in, okay. We have our billionaire client has a portfolio of like $8 billion. 20% of his portfolio is in the shitter. He's being clipped on receivership motions, orders to show cause, so on and so forth, right? And one of the things that we were able to do for him is we were able to stall the receivership for a while, right?
Forever.
How was that? Yeah. How was that beneficial for this client? And the fact that he came to us before that happened, how did it help him? Tell me.
So look, that's one of the best examples that we have in our office. We stalled that out for 10 months. During that 10 months, the property basically was able to be stabilized.
Yes.
To an extent. But look, even in that case, I'll give you an example. We reviewed the transactional attorney's emails with the lender while we were opposing the motion. And guess what? When I read those emails, I'm talking like dozens of emails, They were in litigation months before the law. I saw exactly where this was going 6 months before the receivership application happened.
So litigation for you doesn't mean when a summons and complaint is filed
Absolutely
or even
not,
a demand letter is written.
Correct.
It's when you begin to be in a disagreement.
Right.
So it's not litigation, it's litigious posture.
Yes. That's really when, if you have a transactional attorney, with no disrespect to them, but they really need to step aside and the litigation team has to be brought in.
I mean, talk about transactional attorneys. These fucking guys, man. They're like, oh, yeah, put the notice secure in there. No, don't worry about 7. They make it 3 days. Don't worry about it. And you got the client pushing to make the deal happen. And then you have full recourse guarantees. Tell me about the client that we have with a full recourse guarantee had a fucking panic attack.
They basically, transactional attorneys, what they want to do is they believe that they can make an agreement when it's not possible, especially in this climate.
So what does that mean they're not able to? They are transactional counsel.
They are transactional counsel, but they're not trained to really tell the other side, this is what's going to happen if this continues. Instead, they don't really protect the record. And what I mean by protecting the record is very simple. You have to write clear emails saying, no, we are not amenable to X, Y, and Z because your client, the lender, was in the wrong. We're not in the wrong. I never see that from the attorneys that represent borrowers pre-litigation. There's no protecting the record because they're afraid of ruining the deal. But you know what? In this climate, there's no deal unless you're in court.
I appreciate that. And I'm putting the transactional counsel on blast, okay? And they're not fucking great. They want to make the deal work. They appease the client, and they got to stop fucking doing that. Right?
We had the client. Did the client even understand what they signed?
No. We told the client. No. Talk about how we showed a client the guarantee, and he's like, I didn't sign a guarantee.
I think we printed out 4 or 5 documents, highlighted each provision, and said, this is what you've agreed to. Before.
And what did he say?
I don't believe it. But no, it's not true.
Is that your signature or so?
Yes, it's my signature. Yes. So that was it. And that was it.
And when you call the transactional counsel, what do they say to us?
Anything but what the correct answer was.
Yeah.
And guess what? A year later, we're still in court. We have oral argument on that case next week. So,
So it's about being prepared. When you're confronting the impossible, you have to confront the impossible before you fucking hit the iceberg. Am I correct?
I would do an analogy like karate.
Tell me about that.
If someone is punching you, you have 2 options. You can either block it, dodge it, and then punch back. And if you don't punch back in this market, you're going to get hit eventually.
So there's a place for litigation. We're not a waste of resources or money.
No, in fact, really, the earlier you get a litigator involved, it's actually going to save you money in the end because you're going to get a better result.
And I appreciate that. Yeah. How have you served the market of real estate litigation or business litigation in general? And now that we've advised on $5 billion in debt and equity, we've done a lot, Adam.
Absolutely. No, it's remarkable, and it's also a short amount of time.
27 months, my friend.
That's it.
Tell me about that.
We've had cases where we've had default interest waived for years at a time, where you have a lender who, we're very confident at first agreeing to loan modifications that they would never have agreed to when they stepped in our office.
Yeah. So I want to tell you a story about A. Lifer, how Parkview was foreclosing on him on a $110 million loan. It was in the real deal. Mm-hmm. And it's Friday, okay? It's all close to Shabbat. And I get this a letter from the real deal. We're at the real deal.
Yes.
Abe Lifer's hotel in receiver or move for receiver. And I'm like, I didn't know about this. And that's our client. That's our case. And we go on the docket, the NICEF docket. And Saturday night after Shabbat and Sunday morning, there was a return date on Monday. I negotiated that fucking thing. I was like, if you go forward on this receiver, we're going to push back and we're going to say a whole slew of shit against Parkview, okay? And the guy ultimately caved. And he's like, okay, you know what? I'll give you the extension. Let's get into mediation.
We got four extensions in that case.
Yes.
It was remarkable. It literally, the pendulum swung from being really like you're on the operating table with the CPR to just you're walking out of the hospital within 2 months.
That's right. And, people don't see these things. And we're trying to get as close as possible to people experiencing these things. And that's why we talk about them. But people don't know. They don't know what lawyers do every day. We're distressed attorneys. We're emergency room doctors. Any other anecdotes you want to share?
I always like to use the analogy when they come in, when they come in and they tell us what, where they're at and why they think that they want an attorney. And it's really the MRI where, we say this is what, it's like the ding on the MRI where you see that there's a trouble issue, but really until you bring us in, that's when the surgery begins.
And we do macro, we don't do micro.
That's correct.
I don't think do we focus on like the task at hand, or do we want to be global?
Look, it's global, but usually the people that are coming in here, they need about 5 or 6 surgeries. So it's very obvious that, look, you have this issue, this issue, this issue, this issue. There's a lot of things to do. And
it's often tied to their blood pressure, their cholesterol,
a broken leg.
Their leg or whatever. They come in like, oh, can you fix this? I'm like, no, but your heart's about to stop. Your heart's about to stop.
That's
and you're not taking care of it, I want to thank you for joining us, Adam.
Thank you for having me.
I want to ask you one last question.
Yeah.
What is your litigation style, and how have you used your litigation style to come to a resolution?
My personal belief is being hyper-aggressive at the correct times.
And we're not scared of sanctions, are we, Adam?
No, as you say, get in line.
Get in fucking line, that's right.
Yeah.
That's how we confront the impossible at Jacobs PC. I want to thank you very much for joining us, Adam.
Thank you.
Adam fucking Sherman. Thank you, everybody.
Thank you.